Somebody earlier was interrupting proceedings. Is it the counsel for the defendant?
No, is IT, my lord. Is IT from the ICT. Mr.
Oh, I see.
The camera for Mr. Abdulmalik Isa is not enabled.
Then get in touch with the either the registrar or any of the staff of court so that they can alert him. Mr. Fatai.
Yes, my lord. Yes, my lord.
Usually, I notice there's always noises from your own end, not from the Federal High Court or from the council. So please try and see what you can do about that.
All right, my lord. All right, my lord.
Thank you.
Thank you, my lord.
Thank you. The learned prosecutor, can you hear me?
Yes, my lord.
Can you adopt the processes of the defendant as well, since it's not before the court? You have been served, may not?
Yes, my lord. But my lord, sorry, my lord. The counsel handling the case, my lord, is with the process of the defense, my lord.
Give us a date. July. Rolling. This matter is called. The defendant is at the Pottiscombe Correctional Center, as this proceedings is by virtual mode. The case started by 10 a.m. to enable the Pottiscombe Correctional Center get ready. Yet the defense counsel failed to put in an appearance. Although counsel from the same chambers is before the court and applied for a stand down to enable the substantive counsel to appear. The court did not grant the application, but allowed the prosecuting counsel to move the application and expected counsel to move the final written address of the defense counsel as well. Counsel haven't failed to do that. The matter is adjourned to 7th July 2024 for adoption of final written address by counsel. The matter is to be conducted virtually.
As court, please, my lord.
As the court. As the court pleases. Thank you.
Nan ya ce a ɗaga masa zuwa wani wasu lokuta, wasu mintuna. To wannan ƙorafin da ya sai kotu bata aminta da haka ba. Shi ne kotu ta ɗaga zaman da yanzu zuwa ranar 7 ga watan 7. Za a zo a ci gaba da zaman.
Thank you. Please call the next case.
/CM/CR/24/2021 between the Federal Republic of Nigeria and Ulama Yusuf.
My lord, the defendant is here at the correction center and he speaks English, my lord.
Representation, please.
With respect and humility, my lords, HF Joro is my name. Deputy Director, Public Prosecution. My humble appearance, my lord, is for the prosecution. Thank you, my lords.
Yes.
Suleiman is my name. My humble appearance for the defendant.
Yes. Yes, Counsel, I'm still waiting for you.
My lords,
My lord,
the case is selected for adoption of final written address, of which we are ready, subject to your convenience, my lords.
Yes, go ahead.
we are fully ready, my lord.
My lord, before you is the prosecution final written address dated 15th day of December 2024, my lords, and it was filed on the 26th day of February 2024, my lords. My lord, we hereby adopt same as our final argument and submission in this case, my lord. My lord, we finally urge this honorable court to return the verdict of guilt as charged on the defendants, my lords, and convict in accordingly, my lord. May it please, my lord. Thank you, my lords.
Yes, my lord, before this honorable court is defendant final address dated 14th day of December 2023 and filed on 19th December 2023. And we adopt same as our legal argument and submission in this case. And we finally urge, my lord, to discharge and acquit the defendant. That is our humble submission. May it please, my lord.
This matter is called the defendant who is at the Potiskum Correctional Center, and the proceedings being conducted virtually. Counsel having adopted their final written address, the judgment of court will be delivered shortly.
As per please.
Judgment.
As per please.
The defendant in this case is Bulam Yusuf, who was arraigned before this court by the Nigerian Police Force, and the matter thereof taken over by the Office of the Attorney General, Yobe State Command, on an amended two-count charge, FSC DMC R24-2021, dated 4th January 2022 and filed 15th February 2022 against the defendant. The charge reads that you, Bulam Yusuf, mail on or about the 10th day of June 2021 at about 19:30 hours at Bunyadi Division, Gujba Local Government Area, Yobe State, which is within the jurisdiction of this honorable court, you are the armorer vested with the trust of custody and control of firearm of the division, set the division on fire ablaze in order to destroy and cover the unlawful deal of 823 live ammunitions of 7.62 mm to one Inspector Anjuma Gotham sometimes in the month of September 2020 at the rate of 123,450 naira, knowing fully is prohibited dealing and ammunitions and firearms, you thereby committed an offense contrary to and punishable under Section 28 sub 1B3 of the Firearms Act, Laws of Nigeria 2000, Laws of the Federation 2004. Count 2, that you, Bulama Yusuf, mail on or about the 10th June 2021 at about 1930 hours at Bunyadi Division, Gujba Local Government Area, Yobe State, which is within the jurisdiction of this honorable court. You are the armorer vested with the trust of custody and control of firearm of the division, set the division ablaze in order to destroy and cover the unlawful deal and sold 823 live ammunitions of 7.62 mm to one Inspector Anjuma Gotham, sometimes in the month of September 2020 at the rate of 123,450 naira, knowing fully is prohibited sale and dealing in firearms. You thereby committed an offense contrary to and punishable under Section 28(1)(c)(4) of the Firearms Act, Laws of the Federation 2004. The defendant pleaded not guilty to the charge when he was arraigned on the 29th day of March 2022. Trial commenced. At the trial, the prosecution called 3 witnesses and did not tender any exhibit. The case of the prosecution is summarized below. There's PW1 Bala Isa, who's an officer working with the division and lives at Bunyadi, and inspector by rank, as well as investigation police officer. I'll skip that. I'll go to the second prosecuting witness, who is PW2 DSP Bitrus Mahmoud Saleh, who is the DPO, Gujiba Division, has been with the Nigerian Police Force for 34 years and 10 months. I'll go on to the third prosecution witness, who is Mamman Usman, who is a 29-year-old man that resides at Gas Solar, Bunyadi Gujiba local government, that is a POS operator agent, and that people deposit money and withdraw money from him. I'll skip his testimony for now. Then there's DW1 Bulama Yusuf, that is the defendant, who is a 37-year-old public servant. I'll skip his own testimony. At the conclusion of hearing, the matter was adjourned today to enable counsel adopt their already filed and exchange written addresses. I've skipped some of the testimony of witnesses because I'll review it later in the judgment. So it's going to be a duplication of efforts if I read it now and then read it out later. Now, the defense counsel adopted the defense and prosecuting counsel adopted their already filed and exchanged final written address. The defense counsel, while adopting his written address, submitted a sole issue for determination, which is whether the prosecution has proof of the offense of prohibited ammunitions and prohibited sale and dealing in firearm beyond reasonable doubt. In his argument, counsel answered in the negative and submitted that the prosecution did not place credible and convincing evidence warranting this court to convict the defendant on the offense of prohibited dealings in ammunition, firearms, and prohibited sale and dealings in ammunition, firearms, and that it is tried law that it is better to set 99 people free, accused persons, than to convict a single innocent person, and that no exhibit was tendered in evidence in support of the prosecution's case. The prosecuting counsel adopted a written address and submitted 3 issues for determination, being 1, whether the prosecution has proved its case beyond reasonable doubt as provided by the law. 2, whether the testimony of PW1, PW2, and PW3 that the defendant can be convicted without evidence of corroboration. 3, whether from the evidence of the defendant any form of defense to the charge was established. Prosecuting counsel contended that the testimony of PW1, PW2, and PW3 during trial has proved that the defendant was identified and actively participated in the commission of the offense for which he is standing trial. Finally, counsel urged the court to return the verdict of guilty as charged and convict the defendant accordingly. Above is the summary of the prosecution's case and the defense put up by the defendant on the charge. Both learned counsel, as stated earlier, adopted their final written address earlier in the day, and the already written judgment is about to be read now. To determine whether the offense complained of has been proved against the defendant beyond reasonable doubt, some pertinent questions need to be asked relevant to the matter and answered so as to verify whether the prosecution has proved the offense of prohibited sale and dealing in ammunition and firearms beyond reasonable doubt against the defendant. The questions are: 1, what offense is disclosed in the instant charge? 2, what offense is disclosed in the proof of evidence? 3, what cause of action precipitated preferment of the charge? 4, what are the summarized evidence of the prosecution and defense witnesses in this case? 6, whether the offense complained of has been proved against the defendant beyond reasonable doubt as provided for by the law. Starting with the first question as to what offense is disclosed in the instant charge. The alleged offense in the 2-count charge is that the defendant, being the armorer vested with the trust of custody and control of firearms and ammunition of the Gujiba division, set the division ablaze in order to destroy and cover the unlawful deal of 823 live ammunition of 7.62 mm alleged to have been sold to one Inspector Anjuma Gotham sometimes in the month of September 2020 at the rate of 123,450 naira, knowing fully that the sale and dealing in ammunition, firearms is prohibited pursuant to the firearms laws of the Federation of Nigeria 2004, and thereby committed an offense contrary to and punishable under Section 28B3 and Section 28(1)(c)(5) of the Firearms Act laws of the Federation 2004. The second question to answer is what is disclosed in the proof of evidence, which has the list of exhibits, witnesses, and their addresses. The summary of evidence is reproduced for ease of reference or ease of understanding. 1, list of exhibits, which is confession statements in videotape. B, bank statements of defendants, and Juma Gotham and Malam Baba Adamu. 2, investigating officers. A, Inspector Bala Isa Buni ERD Division, Gujiba Local Government Area, Nigerian Police Command. DSP Bitrus Mahmuda, Bunyadi Division, Nigerian Police, Yobe State Command. Detective Fabian Terhimba, State CID Damaturu, Nigerian Police Force, Malam Baba Adamu Buniyadi Town, Gujiba Local Government Area, and ASP Garba Umar, State CID Damaturu, Nigerian Police, Yobe Command. Now to the third question as to what course of action precipitated the preferment of the charge. This honorable court has to jointly review the charge and proof of evidence, including the surrounding case facts of the case as established by the evidence before the court. This exercise can be achieved having already reproduced the testimonies of both the prosecution and defense witnesses, since there are no exhibits, real or documentary, tendered. Looking at the processes filed before the court reveals that a police division was deliberately set on fire, whereby the armorer vested with the trust of custody and control of firearms and ammunition of the division was suspected of intentionally and deliberately igniting a fire with the aim to conceal the fact that a number of live ammunitions were pilfered. The defendant, who is also the crime recorder and computer operator, is suspected to have pilfered the firearms ammunition as well as the divisional computer that records the activities of the police division. These scenarios precipitated the investigation that led to the preferment of the charge against the defendant, because it was in the course of investigation that it was discovered that 823 live ammunitions were missing from the armory. These heavy allegations were denied by the defendant. Went on to the fourth question. What are the summarized evidence of the prosecution and defense witnesses in this case? The testimonies of PW1, PW2, PW3, and the DW1 is produced below. It reads. I'll now read the testimonies of the witnesses. PW1, Inspector Bala Isa, a police officer within the division, Gujiba Division, and residing in Bunyadi, presented a compelling testimony as a PW1 in a case involving mischief by fire and theft of ammunition. Serving as an inspector and IPO with investigative responsibilities, PW1 recounted his diligent efforts during the investigation. He meticulously recorded statements of the defendant and witnesses in English language, ensuring accuracy and comprehension by reading over and countersigning each statement. He conducted thorough scene examinations, capturing photographic evidence and recovering key items, such as rags with fuel odors and a kitchen knife. Crucially, his investigation revealed the alarming disappearance of 823 rounds of 7.62 mm live ammunition, prompting further inquiry into the defendant, Sergeant Bulama Yusuf, the armorer, who confessed to the theft and subsequent sale of the ammunition to one Inspector Danjuma Goto. Continuing his testimony, PW1 detailed the progression of the investigation, which extended to the arrest of Inspector Goto. The case was later transferred to State CID Damaturu for discreet investigation, uncovered further incriminating evidence. In interviews with the divisional police officer and the deputy commissioner of police at State CID Damaturu, the defendant confessed to not only the theft of ammunition, but also to setting the DPO's office ablaze in an attempt to conceal his criminal activities. The PW1's comprehensive testimony provided a clear narrative of the events surrounding the case, underscoring the gravity of the defendant's actions and the thoroughness of the investigative process. PW2, DSP Beatrice Mahmoud Saleh, who is a 59-year-old veteran of the Nigerian police force, a DPO with over 3 decades of service recounted a harrowing incident on 10th June 2021 when his office was set ablaze. Following the blaze, he initiated an investigation which uncovered the defendant, Sergeant Bulama, as the perpetrator. During questioning, the defendant identified as his armorer and computer operator confessed to igniting the fire out of temptation by the devil. Subsequent inquiries revealed a more sinister plot as the defendant admitted to selling 823 missing ammunitions, initially concealing their absence by borrowing from Mobile 12's inventory, and disclosed selling them to Inspector Anjuma Gotham for 150 naira each, facilitated through various transactions, including cash and POS transactions through POS dealers Malam Mamman Usman and the deceased Malam Baba Adamu in Bunyadi. The PW2 testified that despite initially appearing as an act of arson, the incident unraveled a deeper conspiracy involving theft and illicit transactions within the police force. The defendant's confession not only exposed his own culpability, but also implicated an inspector in the illegal arms trade. With the revelation of financial transactions conducted through POS, the investigation widened, shedding light on the individuals involved in the unlawful activities. The transfer of the case to CID for discreet investigation underscored the gravity of the situation, highlighting the need for thorough scrutiny to uncover the full extent of the corruption within the ranks of law enforcement. PW3, Mamman Usman, is a 29-year-old man residing in Gasola, Bunyadi, Gujiba local government, who works as a POS operator agent. He testified knowing the defendant very well as a police officer at Bunyadi Division, that on 7th January 2021, around 6 p.m., the defendant approached him requesting to use his account for a money transfer from his boss, Maigida, for housekeeping expenses. PW3 provided his master's account number, resulting in several transfers totaling 21,000 to the account, with confirmation calls made to the defendant, who verified receipt. The following inquiries by the police DPO, PW3, and his older brother, Malam Baba Adamu, now deceased, were summoned to CID Damaturu, where they provided statements and bank statements confirming transactions with the defendant. PW3 explained that they were unaware of any wrongdoing, believing the defendant was collecting money for housekeeping for his boss wife. The CID took their statements and phone numbers, releasing them with the understanding they could be recalled for further testimony. That all in all, PW3 facilitated multiple transfers to the defendant from his master's account at the request of the defendant, believing it to be for legitimate purposes. Upon police inquiry, they cooperated, providing statements and evidence, and were released, pending potential further involvement in the investigation. On the other hand, the defendant, testifying in his defense as DW1, testified thus: DW1 Bulama Yusuf, that he's a 37-year-old public servant. He recounted events surrounding his involvement in a case that unfolded on 10th June 2021. He explained that while working late to complete his duties as a station armorer, crime recorder, and computer operator in Bunyadi, his computer failed and malfunctioned when he took it home. Consequently, he took it for repairs. Upon his return to work, suspicions arose regarding the computer's disappearance and allegations of involvement in a fire incident and missing ammunition emerged. that despite denying involvement in these allegations, DW1 found himself detained and subjected to interrogation. Authorities pressed him to confess to setting the station on fire and stealing ammunition, threatening to prolong detention if he refused. DW1 maintained his innocence, highlighting his absence during the alleged incident and his routine work hours. Despite this, he endured some months of confinement, deprived of communication and visitors. That in a turn of events, DW1 was presented with statement forms and coerced into signing them under the premise that his release was imminent. However, he remained in custody until 29th November 2021, when he was finally brought before this court. Throughout this ordeal, DW1 stood firm in his denial of the accusations, insisting on his innocence despite the pressure to admit guilt. This honorable court, having reproduced all the processes in the file as well as the testimonies of all witnesses in the trial, will go on to determine the fifth question, being what correlation is there between the defendant and the offenses charged. The defendant, being the divisional armorer, vested with the custody and control of firearms of the division, as well as the computer operator and crime recorder, holds three key distinctive and sensitive positions with duties and responsibilities regarding the position of trust that he holds. Being in charge of the armory, the defendant as Sergeant Armorer must explain the whereabouts of all arms and ammunition kept in his custody, as this is one amongst his many duties. The charge is alleging that 823 live ammunition of 7.62 mm for a K-47 rifle were missing from the armory, and that the defendant has set the division ablaze in order to destroy and cover the unlawful deal he entered with one Inspector Anjuma Gotham for sale of the missing ammunition at the rate of 123,450 naira, sometimes in the month of September 2020, meaning that there could be an act of illegal dealing, sale or transfer of firearms and ammunition without license by the defendant, which could require an explanation. And lastly, the sixth question, whether the offense complained of has been proved against the defendant beyond reasonable doubt as provided for by the law. The prosecution must discharge this general duty of rebutting the presumption of innocence constitutionally guaranteed to the defendant. This honor never shifts. Now, the burden and standard of proof in criminal cases, as in this one, it is the duty of the prosecution to establish the guilt of the defendant of the offense or offenses charged beyond reasonable doubt in order to secure a conviction. See Section 135, 1 and 2 of the Evidence Act 2011.
As the court pleases.
What does proof beyond reasonable doubt mean? Ugochukwu Anthony Ogaku, JCA, in the case of Adedayo Oladele versus the state 2021 LPLR, held our adversary criminal justice system is accusatorial. This is in tune with Section 36(5) of the Constitution of the Federal Republic of Nigeria, which provides that every person charged with a criminal offense shall be presumed innocent until he is proved guilty. The necessary corollary of this presumption of innocence is that the prosecution has the honors of proving the commission of the crime charged beyond reasonable doubt as stipulated in Section 135 of the Evidence Act 2011. Proof beyond reasonable doubt does not mean that the prosecution must prove the case with mathematical exactitude. There is a state 2011 LPLR. It does not mean proof beyond all shadow of doubt. So where the evidence adduced is strong as to leave only a remote probability in favor of the accused person, then the case is proved beyond reasonable doubt. Now, in a criminal trial, the obligation is on the prosecution to establish the guilt of the defendant by proving all the ingredients of the offense charged. In this case, the defendant is charged under Section 28(1)(b)(3) and Section 28(1)(c)(5) of the Firearms Act laws of the Federation of Nigeria 2004, which provides, I'll skip the section, the prosecution must prove that the section provides that the prosecution must prove that there's illegal dealing, sale, or transfer of firearms and ammunition without a license by the defendant. There are three ways or methods by which the prosecution may prove the guilt of an accused person. These are: one, by reliance on a confessional statement of an accused person voluntarily made; two, by circumstantial evidence; and three, by the evidence of eyewitnesses. See Emeka versus State 2001, Okudu versus the State 2011, 3 NWLR, Olawe versus State 2018, LAPLR. Principally, the charge before the court is that 823 live ammunition of 7.68 mm for an AK-47 rifle is missing from the armory. Certain questions must be asked. A, was ammunition in the division missing? B, in whose primary custody was the arms and ammunition of the division? C, who has the primary duty and responsibility to ensure firearms and ammunition are kept in safe custody? D, where are the missing ammunition kept in the custody of the defendant? Have they grown wings to fly? And if they are flown, where? The above enumerated questions can only be answered by the defendant. The defendant has testified that he is the station armorer, crime recorder, and computer operator in Bunyadi division. Being the armorer, he is vested with trust, custody, and control of firearms and ammunition of the division, and is alleged to have set the division ablaze in order to destroy and cover the unlawful deal of 823 live ammunition of 7.62 mm to one Inspector Anjuma Gotham, sometimes in the month of September 2020, contrary to and punishable under Section 28 of the Firearms Act, laws of the Federation of Nigeria 2004. The defendant, being the person in charge of armory, refused to acknowledge that a large number of ammunition is missing from the armory under his watch. During cross-examination, DW1 was asked whether it is right to say that he is the substantive armorer who takes care of the armory as of that time, and he replied, no, I'm the clerk armorer, and 4 others, that yes, I have access to armor and ammunition. When asked whether it is right to say 729 ammunition are missing, the DW1 answered, DPO said so, not me. The defendant affirmed that he is the only person with access to the computer, and also affirmed that he knows one Anjuma Gotham, who is his friend, and that it is not right to state that fire broke out at the armory. Now, the defendant, as a police officer, must be alive to his responsibilities, as he's holding 3 key sensitive positions in this division, being the crime recorder, computer operator, and sergeant armorer. Keeping custody of a collection of weapons, being firearms and ammunition in a store in the division is part of his duties as an armorer, and when a single firearm or ammunition cannot be accounted for, then the armorer is to be held responsible. The defendant who testified, I so hold. The defendant who testified as the station armorer did not provide a convincing reason as to the disappearance of ammunition in his custody. The defendant feigned ignorance of their disappearance and claimed that the DPO said so, not him, implying that the 823 rounds of 7.62 mm live ammunition of AK-47 caliber are intact and in safe custody because the defendant testified that there was suspicion regarding missing ammunition and an office fire, but denied involvement in both incidents. Now, the million-naira question is, what happened to the missing ammunition amounting not only a few, 20, 50, or even 100, but 827 rounds of 823 rounds of 7.62 mm live ammunition of AK-47 caliber. There is no record before the court to indicate that the 823 rounds of 7.62 mm live ammunition of AK-47 caliber were destroyed in the fire outbreak or properly put arson in the station. The defendant glossed over both incidents, but gave a comprehensive testimony of his detention at the CID in Damaturu. Meanwhile, the PW1 and PW2 are at Edom, that in the course of investigation, when the record of the armory was checked, it was discovered that 823 rounds of live ammunition of AK-47 caliber were missing, in which the defendant, being the armorer, confessed to have stolen the 823 rounds of 7.62 live ammunition and sold them to one Inspector Anjuma Gotham attached to 79 Police Mobile Force PMF Bungari at the rate of 150 naira each, and that they started the transaction since September 2020, and also confessed to have set the office of the DPO on fire in order to burn the station to cover up his crime. The defendant must answer the whereabouts of the missing 823 rounds of 7.62 mm live ammunition of AK-47 caliber, being the person in charge of armory. So when, as I stated earlier, a single arm or ammunition gets missing, he must give a convincing reason why and how. Explain the whereabouts of the missing ammunition kept under his custody. In the instant case, no reason was adduced by the defendant, being the division crime recorder, computer operator, and sergeant armorer. The DPO at the PW2 testified that when the armory was checked and 823 ammunitions were discovered missing, the defendant was asked what happened, as during the monthly returns, ammunition in the armory were intact. The defendant replied that whenever asked, he used to borrow the one of Mobile 12 for safekeeping in the armory, that the PW2 further asked that after separating the Mobile 12 ammunition, after they have collected their own, where is the 823 ammunition? That the defendant replied that he has sold it to Anjuma Gotham and Inspector at the rate of 150 naira each. When further asked how, he answered that he sold it at different times, at different occasions, not at once. Sometimes he will collect the money by hand, sometimes through POS. PW2 testified further that money was collected by the defendant through POS in Bunyadi, and the person operating the POS machine is one man, Mamman Usman, operating with one Baba Adamu, who is now deceased. While the PW3, the POS vendor, confirmed knowing the defendant very well, Farin Sani, in relation to this case, and also knows his family, that the defendant is a policeman who works at Bunyadi Division and used to come to conduct transactions with him. That on the 7th January 2021, in the evening around 6 p.m., he came to PwC's shop and said that somebody, being his boss, Maigida, is going to transfer money to him and that his bank network is poor. Therefore, the PwC should allow him to transact through his account, and that the Maigida, having left his family in Bunyadi, wanted to send money for housekeeping, Tiffany. The PW1 testified that he gave the defendant his master's first bank account number 312165174 Alhaji Adamu Bakpa, that the money was sent, but he does not know by whom. That on that same day, around 9 p.m., 6,000 naira was sent to that POS account. Then a call was made to Sergeant Bulama to confirm to that POS account to confirm whether the witness has seen the money transferred, seen the alert with the name of the defendant, Anjuma Gotham. That thereafter, on the 8th January 2021, another 4,000 naira was sent, still with the same name, Anjuma Gotham, that the defendant called PW2 to confirm, and when he did, the defendant came to collect. That on 13th January 2021, another 2,000 naira with the same name, Anjuma Gotham, was transferred to the account and the defendant came and collected. On 18th January 2021, the sum of 6,000 naira divided into two of 3,000 naira each was collected on same day. The last one was on the 28th January 2021, all in all amounting to 21,000 naira. The defendant on his part denied the allegation and testified that on the 5th June earlier, there was a fire incident at the police office, and that the DPO stated that he's suspecting the defendant of starting the fire and pilfering ammunition, thereby transferred the case to State CID Damaturu, that when the DC CID asked the defendant, he denied that such happened. I don't have an idea of the issue. DW1 testified further that on 18th June by 8 o'clock in the morning, DSP Garba, Inspector Emmanuel Aklama, Inspector Samson Wahi, all went to his house to search if they may see it. They did not get anything in the house, and that they all came back to the CID, where DSP Garba still inquired from the witness, who denied same, that he's not aware of the allegations, that he only knows of the laptop issue, and that in that office there were 4 of them, and the witness claims he does not do night duty. When asked about his business relationship with one Anjuma, he said they are friends and that they work together. When further asked how come the Anjuma was sending him money through his account, to which the defendant answered, in the month of September, Anjuma collected money, the sum of 50,000 from the defendant when he lost somebody. The defendant testified that ASP Garba told him to agree that he had taken either the ammunitions, while the witness contended that there were 4 of them in the office, 1 SPO, inspector, and 1 constable, and having not committed same, he would not affirm to it. Now, it is for the defendant to introduce any evidence he considers necessary or relevant to prove reasonable doubt about the allegation of illegal dealing, sale, or transfer of firearms and ammunition without a license or permit, as alleged in the charge against him, since the evidence adduced by the prosecution established beyond reasonable doubt that 823 live ammunition of 7.62 mm could not be accounted for. and that the armorer could not categorically state where the ammunition is or who has the possession of the ammunition. The evidential burden has shifted to the defendant to establish by a preponderance of evidence that the ammunition is safe and intact, since the defendant is disputing the fact that ammunition in his custody is missing, because when asked whether it is right to say ammunition, 729 ammunition are missing, the DW1 answered, DPO said so, not me. This is in keeping with Section 135(3) of the Evidence Act 2011, which provides that if the prosecution proves that the commission of a crime beyond reasonable doubt, the burden of proving reasonable doubt is shifted onto the defendant. It has to be borne in mind that the evidence which a court is to act upon and ascribe probative value to is legally admissible, credible evidence. See, Honor versus State, 1988 LPLR, and Bukola versus State, 2017 LPLR. The law is now tried that the evaluation in order to ascribe probative value to such evidence is the primary function of the trial judge, who had the opportunity of hearing the witness and observing their demeanor. This exercise enables the judge to determine credible evidence. Credible evidence means worthy of belief, and for evidence to be credible, it should be natural, reasonable, and probable in view of the entire circumstances of the case. I hold very strongly that the testimony of the witnesses in this case is the best guide to the truth of the path taken by them, which will enable the court to determine their worthiness. The testimony of the prosecution witnesses flows without contradiction and corroborates each other as reproduced above, while disopposing the testimony of the defendant, which has some contradictions. In his testimony before the court, the defendant claims that his relationship with one Anjuma, who was sending him money through his account, as well as through POS, is that they are friends and they work together, and that in the month of September 2020, Anjuma collected the sum of 50,000 naira from him when Anjuma lost someone. On the other hand, the POS operator as PW3 testified in court that the defendant told him that his boss, Maigida, is going to transfer money to him to transact through his account, and that the boss, having left his family in Bunyadi, wanted to send money for housekeeping, Chefeni. And a series of transactions took place in January 2021 between the defendant and the boss through the account of PW3. The same transaction, but different explanations given regarding same. The question about the transactions or transfer of money between the defendant and the said Anjuma is, A, was the money sent for housekeeping allowance for the boss wife, or B, for the repayment of a loan between the defendant and Anjuma, or C, for payment of dealing, sale, and transfer of firearms and ammunition without a license by the defendant. The contradictions observed in the evidence raises doubt and does not give a clear picture as to the evidence of the defendant because of the contradictions noticed, in contrast to that of the prosecution. The charge against the defendant as the armorer vested with the trust of custody and control of firearm of the division to set the division ablaze in order to destroy and cover the unlawful deal of 823 live ammunitions of 7.62 mm to one Inspector Anjuma Gotham sometimes in the month of September 2020 at the rate of 123,450 naira, knowing fully is prohibited dealing in ammunition, firearms, and thereby committed an offense under the Firearms Act, laws of Nigeria 2004. By inference, and circumstantial evidence link the defendant with one Inspector Anjuma through financial transactions directly through their accounts and also through the account of PW3 as stated above. The 823 rounds of 7.62 mm live ammunition of AK-47 caliber unaccounted for by the defendant leads to the inevitable conclusion that it has been sold off by the defendant, who has a business deal with one Anjuma. He said they are friends and that they work together must be the reason for the missing 823 rounds of 7.62 mm live ammunition of AK-47 caliber, which business deal led to the sale and transfer of the amounts by the defendant to the state Anjuma, as testified by the IPO that investigated this instant case of Federal Republic of Nigeria versus Bulama Yusuf, FSC DMCR 21, and also reflected in the similar sister case of FSC DMCR 2021, Federal Republic of Nigeria versus Anjuma Gotham before this court. This goes to confirm that the transaction is for dealing and sale of ammunitions by transferring to the defendant through his account the payments made in exchange of ammunition and not for the repayment of debt, stricter sensu. This hypothesis is confirmed to be true by the testimonies of all three prosecution's witnesses, which postulate that the defendant, being the armorer, confessed to have stolen the 823 rounds of 762 live ammunition and sold them to one Inspector Anjuma Gotham, attached to 79 police mobile force PMF Bunugari at the rate of 150 naira each, and that they started the transaction since September 2020, and confessed to have also set the office of the DPO on fire in order to burn the station to cover up his crime. The defendant was asked what happened as during the monthly returns, ammunition in the armory were intact. And he replied that whenever asked, he used to borrow the one of Mobile 12 for safekeeping in the armory. That the PW2 further asked that after separating the Mobile 12, after they have collected their own, where is the 823 ammunition? That the defendant replied that he sold it to Anjuma Gotham, an inspector, at the rate of 150 naira each at different occasions, not at once. Sometimes he would collect the money by hand, sometimes through POS in Bunyadi, and the person operating the POS machine is one man, a Maman Usman, PW3, operating with one Baba Adamu, who is deceased. As defined by law, a crime includes both the act or actus reus and the intent to commit the act, or mens rea, as can be reflected in this case. Criminal intent involves an intellectual apprehension of factual elements of the acts or acts commanded or enjoined by the law. It is usually inferred from the apparently voluntary commission of an overt act. Criminal intent is a prior intention to commit a criminal act with the knowledge that the act is a crime. Now, being a criminal trial, the onus is on the prosecution to establish the guilt of the defendant by proving all the ingredients of the offense charge, that there's illegal dealing, sale, or transfer of firearms and ammunition without a license. Now, for the prosecution to secure conviction on a charge of illegal dealing in arms and ammunition, the burden is on the prosecution to prove the basic ingredients in the two counts in Section 28 of the Firearms Act, which is there is illegal dealing, sale, or transfer of firearms and ammunition without a license. And on the basis of the above evidence and reasoning, what this Honorable Court concluded is that the offense complained of has been proved against the defendant beyond reasonable doubt, and as the burden is on the defendant, being the division armorer, to justify in law where the missing ammunitions are by positive proof that the ammunitions are intact. The testimony of the IPO indicated that during the monthly returns, ammunition in the armory were intact, and that whenever asked, the defendant confessed that he used to borrow the one of mobile police 12 for safekeeping in the armory. That the defendant was further asked that after separating the mobile 12, after they have collected their own, where is the 833 ammunitions? That the defendant replied that he has sold it to Anjuma Gotham and inspector at the rate of 120 and 50 naira each at different occasions, not at once. Sometimes he'll collect the money by hand, sometimes through POS in Bunyadi, and the person operating the POS machine is one Malam Mamman Usman, PW3, operating with one Baba Adamu, who is deceased. This testimony was not challenged by the defense counsel, thereby failing to discharge the state honors on the defense and affirm the contention of the prosecuting counsel that the defendant, as the sergeant armorer and computer operator, has committed an offense and is in contravention of Section 28 of the Firearms Act, Laws of the Federation 2004. Therefore, the prosecution has proved their case beyond reasonable doubt and discharged the honors on them.
As the court
In
pleases.
the words of Oputa JSC of blessed memory in Bakari versus the State, 1987, Supreme Court 1987 LPLR, my Lord stated, proof beyond reasonable doubt stems out of the compelling presumption of innocence inherent in our adversary system of criminal justice. To display this presumption, the evidence of the prosecution must prove beyond reasonable doubt, not beyond the shadow of any doubt, that the person accused is guilty of the offense charged. Absolute certainty is impossible in any human adventure, including the administration of criminal justice. Proof beyond reasonable doubt means just what it means. It does not admit plausible and fanciful possibilities, but it does admit a high degree of cognition, consistency, with an equally high degree of probability. As Denin J, as it then was observed in Miller versus Minister of Pensions, 1947, through All England Report 373, the law will fail to protect the community if it admitted fanciful possibilities to deflect the course of justice. If the evidence is strong, is so strong as to leave only a remote possibility in his favor, which can be dismissed with the sentence, of course, it is possible, but not in the least probable, the case is proved beyond reasonable doubt. Proof beyond reasonable doubt means proof of an offense with the certainty required in a criminal trial. That certainty is that the offense was committed, which is established by proving the essential ingredients of the offense, and that it is the person charged therewith that committed the offense. More often than not, in criminal trials, the pith of the inquiry is not whether the offense is committed, but whether it was the accused person that committed the offense. See, indeed, versus State 2013 NWLR, part 1052. Now I'm moving on to the sixth question. It's whether the offense complained of has been proved against the defendant beyond reasonable doubt as provided for by the law has been answered in the positive. And having answered all the six questions posed earlier and consequent upon my findings above, I therefore hold that the prosecution has proved its case against the defendant, having established beyond reasonable doubt that the first count in the charge being prohibited dealing in ammunition, firearms, contrary to and punishable under sections 28(1)(b)(3), as well as the second count of prohibited sale and dealing in firearms, contrary to and punishable under section 28(1)(c)(5) of the Firearms Act, Laws of the Federation 2004, has been proved beyond reasonable doubt to secure conviction of the defendant. The ingredients of dealing, sell, or transfer of firearms and ammunition without license has been proved by the prosecution, and the defendant guilty of the offense at charge. From the above analysis, through circumstantial evidence, it is obvious that the prosecution has disclosed a prima facie evidence. It has disclosed a prima facie case against the defendant, which has not been contradicted, and has therefore succeeded in discharging the onus of proof based on each beyond reasonable doubt. The defendant, Yusuf, is hereby convicted at charge.
As the court pleases. As the court pleases.
Sentence hearing.
As court pleases.
Any record of previous conviction? Prosecuting counsel.
No, my lord. No, my lord.
Mr. Bulama Yusuf.
My
Mr. Bulama Yusuf.
lord, I'm hearing you, my lord.
Do you have have you understood, do you have anything to say in mitigation?
Yes, my lord.
Yes, go ahead.
My lord, I can speak Hausa, my lord.
Yes, okay, then for the benefit, let Mr. Sali interpret. Go ahead.
My lord, you need a temper justice, my lord.
Just a minute, I'm trying to record you. Yes.
My lord, he said he has a wife and children, my lord.
Yes.
And his mother is alive, my lord.
Yes.
My lord, you need a temper justice, my lord.
Yes.
Then Zaka ba mai taimaka musu. Ban san wani irin hali suke ciki ba.
My lord, he said he doesn't have any assistant.
Is that it?
Chicken.
Dan yanzu ban san makarantar yara na ya riga ya ɓaci. Ita matan nawa ban san yadda take ba kuma ga mahaifiyata tana cikin wani hali.
My lord, you don't know in which condition his children are, and his wife and mother in all, my lord.
Mr. Yes.
My lord, not commit.
Can you get in touch with the council disturbing the proceedings of court?
As the court pleases.
I do not know which council. You need to mute yourself to enable the proceedings to continue.
Pleases.
Yes.
Ina neman alfarma wajen ki. Na kuskure.
My lord, you need a temper justice, my lord.
Yes.
It's okay, my lord, you say.
His counsel, do you have anything to add? Yes.
My lord, the convict is remorseful of his action. And if given, he will give his own contribution to the society. He is a young person, my lord, as the court has heard from the convict himself. And my lord, it has been decided in electoral authorities that the purpose of conviction is not to punish the convict, but rather to reform and rehabilitate him. And finally, justice with mercy and be lenient to the convict while sentencing, my lord. May it please, my lord, thank you for that of audience.
Sentence.
Stop, please.
Having listened to the plea in mitigation made by the convict, and this honorable court having taken all that into account, in passing sentence on the convict, I take into consideration that he's a first-time offender before this court. Therefore, inasmuch as he's a first-time offender, the charge brought before this court is quite heavy. Therefore, there's a need to give a deterring sentence to send the message that such acts are not acceptable.
As court pleases.
But what is perplexing to me is one person is made the armorer as well as the computer operator of the division. Both duties are very sensitive to the running of the division. The convicts utilize the trust reposed in him to abdicate his responsibility as a Nigerian policeman to turn dark and undermine the system, thereby jeopardizing the security of Bunyadi citizens and by implication, the citizens of this country.
Mr. Court pleases.
The office of a police officer is that of trust. Whenever there's any problem or difficulty, citizens rush to the police for help and assistance, as policemen are public servants. Now, for such a policeman to abdicate this trust is alarming. For him to willingly sell out ammunition held in trust for the well-being of Nigerian citizens, he colluded with a fellow police officer to pilfer ammunition and sell. And from the evidence before the court, when the defendant realized that he cannot continue doing that without repercussions, as a day will come when he must account for the missing ammunition, he decided to get rid of the evidence by arson, burning the Bunyadi division to hide the fact that a large number of ammunition, 823, cannot be accounted for. And not only that, as the computer operator of the division, he claims that the computer fell, leading to its malfunction, and did not report same until asked of the whereabouts of the computer. The court came to this realization from evaluating the testimonies before the court and observing the witness in court. The issue of a missing computer and the issue of arson against the convicts are very grave allegations and leave so much to be desired from an officer of the Nigerian police force.
As the court pleases.
Analysis, I hereby sentence the convict Bulama Yusuf to 4 years imprisonment for the offense he has been convicted of, to commence from the date of arraignment, being the 29th November 2021. The sentence is to serve as punishment to you and a deterrent to others. This honorable court admonishes you to stay away from crime or any of its appearances. Essentially, the essence of punishment is to obtain a reformation in the subject. You are enjoined to stay true to your words and lead an exemplary life after serving your sentence. This shall be the court sentence of the convict, which sentence is no doubt very light.
As the
It
court
was
pleases.
deliberately made so in order to encourage the convict to quickly retrace his steps and return to the society as a changed person. This shall be the court's sentence. The
As the court
convict
pleases.
has 90 days within which to appeal both the conviction and sentence if he is not satisfied with same.
As the court pleases.
As court please, my lords.
Okay.
Thank you, madam.
Thank you.
Okay.
Thank you, my lord, for the sound judgment. We are not grateful, my lord.
Please, can you call the next case?
Thank you, my lord.
Charge number FSC/DM/CR/6/2022 between the Federal Republic of Nigeria and Yayele Mohammed.
Just a minute. This case 2 is for virtual. Sorry? Is that all the cases for the agent's office? So you call that case.
Charge number FSC/D Republic of Nigeria and Danjuma Gotham.
My lord, the defendant is here present at the correction center. And he speaks also, my lord.
Representation. No representation.
My lord,
Respectfully and humility to your lordship, A. Suleiman is my name. For the defendant.
Is the prosecuting counsel not in court?
my lord, with all respect and humility, sorry, my lord, I lost a connection, my lord. HF Joro is my name. For the prosecution, sorry, my lord, thank you.
Yes.
My lord, the case is submitted for judgment, my lord.
Judgment.
So please.
The defendant in this case is Danjuma Gotham, who was arraigned before this honorable court by the Nigerian Police Force, which matter was taken over by the Attorney General's office on a 2-count indictment containing a charge number FSC DMCR 21, 2021, dated the 14th March 2022 and filed 17th March 2022. The charge reads that first count that you, Danjuma Gotham, mail on or about the 16th September 2021 at about 14 hours at Bunyadi Division, Gujiba Local Government Area, Yobe State, which is within the jurisdiction of this honorable court, illegally bought 800 23 rounds of live ammunition, 7.62 mm AK-47 rifle from one Sergeant Bulama Yusuf, armorer of the division, at the cost of 150 naira per one, knowing fully it is restricted and prohibited dealings in arms or ammunition without license or permit, an offense contrary to and punishable under Section 28(1)(b)(3) of the Firearms Act, laws of the Federation of Nigeria 2004. Count 2, that you, Danjuma Gotham, mail on or about the 16th September at about 2021 at about 14:00 hours at Bunyadi Division, Gujiba Local Government Area, Yobe State, which is within the jurisdiction of this honorable court. You illegally bought 823 rounds of live ammunition of 7.62 mm of AK-47 rifle from one Sergeant Bulama Yusuf, armorer of the division, at the cost of 150 naira per one, knowing fully you are not a registered dealer, and such prohibited dealings in arms or ammunition without license or permit and in contraventions of the Firearms Act, you thereby committed an offense contrary to and punishable under Section 28(1)(c)(5) of the Firearms Act, laws of the Federation of Nigeria 2004. The defendant pleaded not guilty to the 2 counts charged when he was arraigned on the 20th day of March 2022. Trial therefore commenced. After legal skirmishes about proof of evidence and failure to bring the defendant from the Pottiscombe Correctional Center quite a number of times. At the trial, the prosecution called 2 witnesses and tendered a documentary exhibit, the extrajudicial statement of the defendant. The case of the prosecution is summarized below. PW1 Fabian Terhemba. I'll skip his testimony because it's somewhere in there. I'll get back to that later. PW2 is Mamman Usman. This is a POS operator. And the exhibits, the defense counsel, when given an opportunity to examine the witness on his testimony, declined by stating no cross-examination. 1 exhibit was tendered and admitted in evidence in support of the prosecution's case, which is exhibit Anjuma Bottom 1, which is the statement of the defendant in English language dated 24th June 2021 as recorded by PW1. At the close of the prosecution's case, the defendant chose to give evidence in his defense as DW1. The case of the defense is summarized. DW1 and Juma Gotham. I'll skip his own testimony. I'll go back to that later, the judgment. At the conclusion of hearing, the matter was adjourned to enable counsel file and exchange their final written address, which they adopted. The defense counsel formulated a sole issue for determination, while the prosecuting counsel formulated 3 issues for determination. Therefore, the above is the summary of the prosecution's case and the defense put forward by the defendant on the charge. To determine whether the offense complained of has been proved against the defendant beyond reasonable doubt, some pertinent questions relevant to the matter need to be asked and answered so as to verify whether the prosecution has proved the offense of prohibited sale and dealing in ammunition and firearms beyond reasonable doubt against the defendant. The first question is what offense is disclosed in the instant charge? Secondly, what offense is disclosed in the proof of evidence? 3, what course of action precipitated preferment of the charge? 4, what are the summarized evidence of the prosecution and defense witnesses in this matter? 5, what correlation is there between the defendant and the offense he's charged with? 6, whether the offense complained of has been proved against the defendant beyond reasonable doubt as provided by the law. To answer the first question as to what offense is disclosed in the instant charge, the alleged offense is that the defendant on or about the 16th September 2021 at about 14:00 hours at Bunyadi Division, Gujiba Local Government Area, Yobe State, illegally bought 823 rounds of live ammunition, 7.62 mm of AK-47 rifle from one Sergeant Bulama Yusuf, armorer of the division at the cost of 150 naira per one, knowing fully it is restricted and prohibited dealings in arms and ammunition without license or permit, and knowing fully that it's not a registered dealer and such prohibited dealings in arms or firearms without license or permit in contraventions of the Firearms Laws of the Federation of Nigeria, 2004. The second question to answer is what is disclosed in the proof of evidence, which has the list of exhibits, witnesses, and their addresses. The summary of the evidence is reproduced for ease of reference. One, list of exhibit, bank statements of accounts and other documents. Two, investigating officers, DSP Bitrus Mahmudu Buniyadi Division, Police, Nigerian Police Buniyadi Division, Yobe State Command, Sergeant Bula Yusuf Buniyadi Division, Nigerian Police Command, Inspector Bala Isa Buniyadi Division, Yobe State Command, Maman Usman Buniyadi Town, Gujiba Local Government Area, Yobe State, ASP Garba Umar, State CID Damaturu, Nigerian Police Command, Detective Fabian Terhemba, State CID, Nigerian Police, Yobe State Command. Now on to the third question as to what course of action precipitated the preferment of the charge. This honorable court has to gently review the charge and proof of evidence, including the surrounding facts of the case as established by the evidence before the court. This exercise can be achieved having already reproduced the testimonies of both the prosecution and defense witnesses in conjunction with the documentary exhibits tendered. Looking at the processes filed before the court reveals that a police division was deliberately set on fire, whereby the Amara 1 Sergeant Bula Maisu, vested with the trust of custody and control of the firearms and ammunition of the division, was suspected of intentionally and deliberately igniting a fire with the aim to conceal the fact that 828 live ammunition of 762 mm for AK-47 rifle were pilfered, and which the said Amara was alleged to have illegally sold to the defendant, Danjuma Gotham of 79 Police Mobile Force, Bunit Gari, at the rate of 150 Naira per ammunition, totaling 123,450 Naira, that the defendant has received the 823 AK-47 live ammunition of 762 mm and transferred the money through his bank account to POS business account of Madam Baba Adamu, now deceased, and Madam Usman, that the POS agents in turn, remitted the money to the said Amara Sergeant Bulama Yusuf. These scenarios precipitated the investigation that led to the preferment of the charge against the defendant for prosecution. The testimonies of PW1, PW2, and DW1 is produced again below. These heavy allegations were denied by the defendant. Going on to the fourth question, what are the summarized evidence of the prosecution and defense counsel witnesses in this case? The testimonies of PW1, PW2, and DW1 is produced below. It reads, PW1, Inspector Fabian Terhemba is a 47-year-old investigative police officer attached to the state CID Damaturu, an inspector with more than a decade of service, presented testimony as PW1 that while on duty at the state CID on 24th June 2021, a case of mischief by fire, theft, and arms deal was transferred from Buniyadi Division to state CID and referred for discrete investigation, which SP Garba Umar and team were detailed to investigate, and that he was one of the team that investigated the case and testified that the statement of the defendant was recorded under words of caution voluntarily and by his free will in a very good atmosphere and condition. After the interview, PW1 testified that they were instructed to go and bring the defendant statement. And Juma Gotham, while they printed the account statement from First Bank and Access Bank of the transactions made between him and one Bulama Yusuf in the involvement of buying and selling ammunition. PW1 testified further that the police internal trial started and went and gave evidence at a guardroom trial, and later the court was charged to court. PW2, Mamman Usman, is a 52-year-old man and a POS operator. He testified knowing the defendant that about 2 years ago, one Bulama Yusuf approached him in the shop in Buni and requested to use his account for money transfer from his boss, Megida, that he has a certain master in the office that transfers, that the man will be sending the wife housekeeping allowances while the said Bulama will be collecting. The PW3 therefore provided his master's account number with which the money was transferred, resulting in several transfers totaling 21,000 naira. The witness testified that he does not know the person sending the money, as he was told that it was meant for the wife of the defendant's boss, Megidanshi, at his duty post, Wajan Aiki. The witness testified that what he knows is that the same account of First Bank is where he receives the alert, that ultimately a set of 6 transactions was conducted all in 1 month. The whole sum sent was 21,000 naira. That's about 4 to 5 months. After about 4 to 5 months, the police DPO in Bunyadi met him at the shop and invited him to the division, where he was asked about whether he did any transaction with one Bulama Yusuf, to which he affirmed that he can remember. The next day, he went to CID Damaturu, where he submitted his statement of account, which has all the transactions mentioned, reflected in that money was transferred to him a total of 6 times, that he informed the police that he does not know the transferor, and they pointed out that this is Gotham, that he was sending the witness money, that he informed that he's sending the defendant money, that he informed them that he does not know him, that it was Bulama Yusuf that collected his account number and forwarded it to the said Gotham. On the other hand, the defendant testifying in his defense as DW1 testified thus: DW1 and Juma Gotham is a defendant, an ex-policeman who previously served at 79 PMF in Haba Maza on special duty, recounted events beginning on July 1, 2019, that he experienced issues with his guns, and following his unit commandant's advice, had it repaired by Sergeant Bulama, the armorer. A colleague faced similar issues, and they both sought Bulama's assistance, eventually obtaining his phone number for future problems. That on October 18, 2019, the defendant received news of his mother's death, and unable to gather funds from colleagues, borrowed 50,000 naira from Bulama. After attending the burial in Jos and returning, the defendant was posted to the JTF in Damagun, during which he informed Bulama. He decided to inform Bulama to avoid misunderstandings. He transferred 29,000 naira and later 21,000 naira to repay the borrowed amount. And upon completing the assignment at Damagun, the defendant was arrested at the police headquarters in Damaturu and detained at the CID for nearly 11 months. before being brought to court. During his detention, he underwent a guard-room trial conducted by two CSPs and had his statements recorded by an IPO named Fabian at the state CID. He consistently denied the charges both in his statement and in court, maintaining that he had repaid Bulama and did not commit the alleged offenses. The defendant pleaded for the court's assistance, asserting his innocence. The court hearing reproduced the extrajudicial statement of the defendant as recorded by the PW1. I read, I, Anjuma Gotham, was born and brought up in Panching, local government area of Plateau State. I'm married with one wife and blessed with 2 children. I'm a policeman attached with 79 PMF Bunigari, Yobe State. Currently, I'm on standby at the base. Sometimes in September 2020, I know one Amara of Gujiba Police Station named Bulama Yusuf, male, we Mopor men, we are posted at the police station. Sometimes he will come and stay with us at sandbag at gate of the police station. Sometimes I will use his bicycle and go to the market. In same September 2020, sometimes I use his bicycle. I went to the market. In the same September 2020, I took my AK-47 rifle to him for service. On 18th October 2020, I lost my mother. Her name is Tauna Gotham in Jos Plateau State. I called him and told him that I need 50,000 to borrow me on 19th, to borrow. And on 19th October 2020, when he, Bulama Yusuf, came to work, I went and met him and he borrowed me the same money. And I went and did the burial. I did not buy any live ammunition from him. Maybe Bulama Yusuf hear what happened to me, to my involvement of arms deal. That connects between me and one Wada Simon. That was why he too alleged me and he sold ammunition. I did not buy any ammunition from him. I swear I did not have anything to do with the said ammunitions. It is only 50,000 naira which I borrowed cash at hand. That money I borrowed, I paid instrumentally. First payment was 4,500. Someday I paid him 3,000, sometimes 2,000, and so on. I paid him up to 15 times. Total amount is 48,000 naira. I'm yet to balance his remaining 2,000 naira. I paid this money through his Access Bank account. I normally transfer the money on my phone. Only 3 times which I paid to POS account. One in Hayababa of Bunyadi. My bank, which I always transfer through phone bank name, First Bank account number. He stated the number. I can provide my statement of account, end of his statement. This honorable court, having reproduced all the processes in the file as well as the testimonies of all witnesses in the trial, will go on to determine the 5th question, being what correlation is between the defendant and the offenses charged. The charge is alleging that the defendant entered an unlawful deal with the Amara of the division, who set the division at blaze in order to destroy and cover the sale of the 823 live ammunition of 7.62 mm for a K-47 rifle. that the missing ammunition was sold to the defendant at the rate of 123,450 naira, sometimes in the month of September 2020. Now, with the missing ammunition from the armory, means that there could be an act of illegal sale or transfer of firearms and ammunition without license by the defendant, which could require an explanation. Lastly, the sixth question, whether the offense complained of has been proved against the defendant beyond reasonable doubt as provided for by the law. The prosecution must discharge this general duty of rebutting the presumption of innocence constitutionally guaranteed to the defendant. This honors never shifts. Now the burden, a standard of proof in criminal cases as this one, is it is the duty of the prosecution to establish the guilt of the defendant of the offenses or offenses charged beyond reasonable doubt in order to secure conviction. See Section 135, 1 and 2 of the Evidence Act. I've also cited the ingredients of the offense charge, that's Section 28(1)(b)(3) and 1(c)(5) of the Firearms Act is reproduced. I'll skip the provision of the law. It is herein reproduced. The prosecution must prove that there's illegal dealing, sale, or transfer of firearms and ammunition without license by the defendant. And there are three ways or methods by which the prosecution may prove the guilt of an accused person. One, by reliance on the confessional statement of an accused person voluntarily made. Two, by circumstantial evidence. And three, by the evidence of eyewitnesses. See Emeka versus State 2001, Okudo versus State 2011, and Olawe versus State 2018 LPLR. Principally, the charge before the court is that the defendant, who is not a license holder for the sale of arms of ammunition, is involved in dealing, sale, and transfer of 823 live ammunition of 762 mm of an AK-47 rifle through financial transactions with one Amora Bulama Yusuf at Bunyadi Division. The defendant, as a police officer, is denying the allegations against him, both in his extrajudicial statement and in his testimony before the court. I've noticed some discrepancies in his testimony in court and the extrajudicial statement regarding the date. In his testimony in court, the defendant testified that on 18th October 2019, he received the news of his mother's death and, unable to gather funds from colleagues, borrowed 50,000 from Bulama. While in his extrajudicial statement, the defendant stated that on the 18th October 2020, I lost my mother. Her name is Tawuna Gotom in Jos Plateau State. I called the defendant and told him that I need 50,000 naira to borrow me on 19th October 2020, when he, Bulama Yusuf, came to work, and I went and met him, and he borrowed me the said money, and I went and did the burial. The contradiction relates to the date. One date is 18th October 2019, while the other is 18th October 2020. The question is, which is the genuine date that the defendant's mother died between the two dates? Is it 2019 or 2020? it has to be borne in mind that the defense, that the evidence which a court is to act upon and ascribe probative value to is legally admissible, credible evidence. See Honor versus State 1988 LPLR and Bukola versus State 2017 LPLR. The law is straight that the evaluation in order to ascribe probative value to evidence is the primary function of the trial judge, who had the opportunity of hearing the witnesses and observing their demeanor. This exercise enables the court to determine credible evidence. Credible evidence means worthy of belief, and for evidence to be credible, it should be natural, reasonable, and probable in view of the entire circumstances of the case. I hold very strongly that the testimony of the witness in this case is the best guide to the path taken by them, which will enable the court to determine their worthiness.
As the court pleases.
The testimony of the prosecution witness flows without contradictions and corroborates each other as reproduced above. While the testimony of the defendant has some bit of contradictions.
As the court pleases.
In his testimony before the court, the defendant claims that his relationship with Bulama Yusuf is his friend. He is an Amora. And that on the 18th October 2019, his mother died in the village and he applied from his unit commander for him to approve, to enable him to go and look for money from his colleagues to enable him to travel. He did not get assistance from his colleagues, so he asked Bulama, who gave him 50,000 naira. DW1 testified that he got approval and left for Jos for the burial and came back after 3 weeks and reported at the office. That he was asked about the charges, which he denied and told them his relationship with Bulama about money, which he has since repaid. And that Bulama called him one day that he wanted to use the money, and the defendant transferred 29,000 to his account and told him to be patient as the money is not complete, and also transferred the sum of 21,000 through POS because Bulama told him he was having challenges with his account. On the other hand, the POS operator as PW3 testified in court that the defendant told him that his boss, Megida, is going to transfer money to him, but his bank network is poor, that the PW3 should allow him to transact through his account, and the boss, having left his family in Bunyadi, wanted to send money for housekeeping Tiffany. The witness testified that he does not know the person sending the money, as he was told that it was meant for the wife of the defendant's boss, Megirenshi, at his duty post. And a series of transactions took place in January 2021 between the defendant and his boss through the account of PW3, that ultimately a set of 6 transactions was conducted all in 1 month. The whole sum sent was 21,000 naira. The same transactions with different explanations given regarding same. The question about the transactions or transfer of money between the defendant and the said Bulama is, A, was the money sent for housekeeping allowances for the boss wife's housekeeping, or B, for the repayment of a loan between the defendant and Anjuma, or C, for the payment of dealing, sale, or transfer of firearms and ammunition without a license by the defendant. The contradictions observed in the evidence raises doubt and does not give a clear picture as to the evidence of the defendant. The charge against the defendant is that his friend, the Amara of the Bunyadi Division 1 Bulama Yusuf, vested with the trust and custody and control of firearm of the division, made an unlawful deal, sale and transfer of 823 live ammunition of 7.62 mm with the defendant sometimes in the month of September 2020 at the rate of 123,450 naira, knowing fully is prohibited dealing in ammunition and firearms, and thereby committed an offense under the Firearms Act, Laws of the Federation 2004. By inference and circumstantial evidence, linked the defendant with the Amara 1 Bulama Yusuf through financial transactions directly through the accounts and also through the account of the PW3 as stated above. The 823 rounds of 7.62 mm live ammunition of AK-47 caliber unaccounted for AK-47 caliber, which business deal led to the sale and transfer of the ammunition by the Amara to the defendant, as testified by the IPO that investigated the case. That investigated this instant case of FHC DMCR 21, Federal Republic of Nigeria and Gotham, and also reflected in the similar case, sister case of FRN Bulama Yusuf FSC DMCR 2021 before this court. This goes to confirm that the financial transactions is for dealing and sale of ammunition by transferring by the defendant through his account the payments made in exchange of ammunition and not for the payment of debt to the censor. This hypothesis is confirmed to be true by the testimonies of both the prosecution witnesses, which postulate that the Amara deal sold and transferred the 823 rounds of 7.6 live ammunition and sold each one at the rate of 150 naira, having started the transaction since September 2022 to the defendant, Inspector Anjuma Gotham, attached to 79 Police Mobile Force, PMF Bulo Gari. PW1, who is one of the members of the team that investigated the case and testified that they were instructed to go and bring the statement of the defendant, Anjuma Gotham, while they printed the account statement from First Bank and Access Bank of the transactions made between him and Bulama Yusuf in the involvement of buying and selling ammunition. Meanwhile, the defense counsel challenged PW1 through cross-examination that during the recording of the statement of the defendant, he informed PW1 that he lost his mother sometime in October 2020, and he collected the sum of 50,000 naira from Bulama Yusuf. The PW1 affirmed that PW1 denied being informed that there was a time that the said Bulama Yusuf collected money from the defendant when he ran into some problems, which means that the deal started in September 2020 before the death of the defendant's mother in October 2020. The PW1 testified that about 4 to 5 months, the police DPO Bunyadi met him at the shop and invited him to the division, where he was asked about whether he did any transaction with Bilal Yusuf, to which he affirmed that he can remember. The next day, they went to see Damaturu, where he submitted his statement of account, which has all transactions mentioned reflected in that money was transferred to him a total of 6 times. That he informed the police that he does not know the transferor, and they pointed him out that this is Gotham that was sending the money, that he informed them he does not know him, that it was Ghulam Yusuf that collected the witness account and forwarded it to the said defendant, and the said sum of 21,000 was transferred to him in a total of 6 times. As defined by law, a crime includes both the acts or actus reus and the intent to commit the act, or mens rea, as can be seen reflected in this case. Criminal intent involves an intellectual apprehension of factual elements of the act or acts commanded or enjoined by the law. It is usually inferred from the apparently voluntary commission of an overt act. Criminal intent is the prior intention to commit a criminal act with the knowledge that the act is a crime. Now, being a criminal tribe, the onus is on the prosecution Okay. Can you still hear me? Okay. Now, for the prosecution to secure conviction on a charge of illegal dealings in arms and ammunition, the burden is on the prosecution to prove the basic ingredients in the 2 counts in Section 28 of the Firearms Act, which is illegal dealing, sale, or transfer of firearms and ammunition without a license. And on the basis of above evidence and reasoning, what this honorable court concluded is that the offense complained of has been proved against the defendant beyond reason.
As court pleases.
Prosecution counsel, can you hear me? Am I still visible on your device?
No, madam.
I'm lost.
Now, Oga. Okay, no problem. Okay. No problem. Okay.
Can you see me?
No, my lord, we can't see you.
Okay. I'm so sorry. I've been having challenges with my own devices here as well.
No problem, my lord.
I've almost come to the end of the judgment. I can
Yes,
see.
my lord. Yes, my lord. But we can hear you very well, but we can't see you.
Oh, I see.
Yes,
Even
my
now,
lord.
you can't see me?
Yes, I can see you. I don't know from the other council.
The Defense Counsel is telling me that he can see me. How about the Correctional Center?
My lord, we didn't see you at all, my lord.
My lord, for the prosecution, we can't see you, but we can hear you very well.
Because I can see the Correctional Center. I can
We
see
cannot
the
see you, my lord.
I can see. Oh, you can now see me?
We cannot. We can't see you, my lord.
This is quite unfortunate. Bring the system. Just give me a minute, please.
Yes, right.
This one is for the phone. Can you see me now?
My
Yes,
lord, we can
yes,
see
ma'am.
you now.
I can see you now, my lord.
Yes, we can see you now.
We can see you now, my lord.
Okay, thank you so much.
That's privilege.
I'm so sorry for the challenges we are having.
That's
No
privilege.
problem, my lord. We'll make it.
I'll go on to the resolving the sixth question,
That's
Yes, my
privilege.
lord.
which
God
is
pleases, my
whether
lord.
the offense complained of has been proved
As God
against the
pleases, my lord.
defendant beyond reasonable doubt as provided for by the law, which has been
As God
answered in
pleases.
the positive, and having answered all the six questions posed earlier, and consequent upon my findings above, I therefore hold that the prosecution has proved its case against the defendant, having established beyond reasonable doubt that the first count in the charge being prohibited dealing in ammunition, firearms, contrary to and punishable under Section 28, 1B3, as well as the second count of prohibited sale and dealings in firearms, contrary to and punishable under Section 28, 1CV of the Firearms Act of the Laws of the Federation of Nigeria 2004 has been proved beyond reasonable doubt to secure conviction of the defendant.
As the God
Ingredient
pleases.
dealing, sale, and transfer of firearms and ammunition without a license has been proved by the prosecution, and the defendant guilty of the offense as charged. From the above analysis, through circumstantial evidence, it is obvious that the prosecution has disclosed a prima facie case against the defendant.
As the God pleases, my lord.
Which has not been contradicted and has therefore succeeded in discharging the onus of proof placed on it. Beyond reasonable doubt, the defendant, Andrew Magotam, is hereby convicted as charged.
As God pleases, my lord.
The prosecuting counsel, any record of previous conviction?
No, my lord. No record, my lord.
Mr. Andrew Magotam, can you hear us?
My lord, we are hearing you now.
Mr. Andrew Magotam.
Yes, ma'am.
I didn't hear him. Do you have anything to say to the court?
I'm not hearing you, ma'am.
He didn't hear my lord very well.
I said for the convict, Mr. Andrew Magotam,
Yes, ma'am.
do you have anything to say to the court? Can you hear me now?
Do you have anything to say to the court?
Yes, ma'am.
Okay. Do you have anything to say
Yes,
to the
I
court?
have 3 reasons. Okay.
Please, can you speak up so that I can record you?
Speak up, you are loud.
1, since I did CID, I lost my father. We are 5 in number. I'm the only man in my father house. 4 women. I'm the only one that I'm a man in our house. That I lost my father and you CID. They are aware with it. And up to now, I don't know how our properties they are. 2, I have
Just 1 minute. I need to record you. I'm writing.
As the court pleases, my lord.
Court pleases.
I have 5 children. 2 they are in university, all of them.
Mr. Gotham.
Yes, ma'am.
Hold on for a minute.
Do it bit by bit, one after the other. Slowly.
I have 5 children, one wife.
Yes.
One is at the University of Bauchi. One, she's at the University of Jos. All of them, they are not going to school now because of this problem. I don't know which condition they are now.
University of Bauchi and
University and
yes.
Yes, ma'am.
Yes. Anything more to add?
3, and I have wife. I don't know which condition that they are. I seek for mercy from.
Is that all?
Yes, ma'am.
Sentence.
As court pleases.
Haven't listened to the plea investigation. Can you hear me?
Yes, my
Yeah,
lord.
Haven't listened to the plea mitigation made by the convicts, and this court haven't taken all that into account. I take into consideration that it's a first-time offender before this court. However, I have to take into consideration the heavy allegations earlier made against him, to which he has been convicted. Therefore, there's need to give a deterrent sentence to send the message that such acts are not acceptable. The defendant is a policeman who utilized the trust reposed in him to abdicate his responsibility as a Nigerian policeman, to turn back and undermine the system, thereby jeopardizing the security of Nigerians. The office of a police officer is that of a trust. Whenever there's any problem or difficulty, citizens rush to the police for help and assistance, as policemen are public servants.
As court pleases.
As court pleases.
Now, for such a policeman to abdicate this trust is alarming. For him to willingly buy ammunition held in trust for the well-being of Nigerian citizens. He colluded with a fellow police officer to undermine the system is really sad and leaves so much to be desired from an officer of the Nigerian police force. In the final analysis, I hereby sentence the convict Anjuma Gotham to 4 years imprisonment. For the offense, he has been convicted of to commence from the date of arraignment. The sentence is to serve as punishment you and a deterrent to others. This honorable court admonishes you to stay away from crime or any of its appearances. Essentially, the essence of punishment is to obtain information in the subject. You are enjoined to stay true to your words and lead an exemplary life after serving your sentence. This shall be the court sentence of the convict, which sentence is no doubt very light. It was deliberately made so in order to encourage the convict to quickly retrace his steps and return to the society as a changed person. The convict has 90 days within which to appeal both the conviction and sentence if he's not satisfied with staying.
As the court pleases. Thank you, my lord, for the sound judgment.
I'm much grateful, my lord, for this eloquent judgment. Thank you, my lord, for the time.
My lord, we are much grateful for this sound judgment. Thank you, my lord.
Do we still have any virtual matter?
No, my lord, that is only for that part just
Any
my lord,
cases? Yes, somebody's. Somebody wanted to say something?
Yes, it's from the prosecution time inside, my lord. Thank you for your time. Thank you for the sound judgment. We take our leave. That's all for us. Thank you, my lord, for today.
Only my problem with the prosecution, I do not know.
My lord?
I'm not really very happy with the way prosecution counsel from the Aegis chambers conduct their proceedings before this court.
My lord, we will do the needful and correct ourselves.
But you know what I'm talking about. Thank you, counsel.
Thank you, my lord, for the guidance.
Okay,
thank you, my lord.
Any other counsel? Counsel, come back and sit. Any other counsel on the platform? Hi, Abdul Malik.
Yes, my lord.
Do you still have a case?
Yes, my lord, I do. Federal Republic of Nigeria and Audi. Ibrahim Audu, I mean.
The registry of court case, you need to inform counsel of.
This morning we received a text message from the prosecution counsel stating that he will not be able to make it to court today due to ill health. He sincerely apologized for the court and all counsels involved. He promised to send a formal correspondence to this people. Thank you.
Mr. Isa, are you still there? Any of the defense counsel on the platform?
Yes, my lord. My lord.
The rest of the cases for today is for the NDLEA.
As a court pleases.
Defense counsel?
Yes, my lord.
The problem is the NDLEA counsel, who has always been diligent in coming to court, is not present in court today.
As court pleases.
As court pleases.
Yes, I'm still waiting to hear from you. And I noticed that the challenge we are having with the network. But the most important thing is the prosecuting counsel is not before the court.
As the court pleases, my lord.
Yes, I wanted your input.
My lord, I am Z.I. Mustafa, Mrs. My lord.
Yes.
I am for the case of Federal Republic of Nigeria versus Ali Polo.
Which is for?
Is for continuation of hearing, my lord.
Yes.
My lord, in the circumstance, as we have been intimated by the registry,
Yes, go ahead.
my lord, we have no option other than to seek for an adjournment, my lord.
Yes.
In the overriding interest of justice, my lord. Though, my lord, this case has, the court can bear me witness that this is the third time this case is coming up for hearing via virtual mode, my lord. And not a single progress has been achieved yet. It is still a 2022 case with just a single witness taken, my lord. That is my humble submission, my lord. We are asking for another date, my lord. May we be guided by the court's diary for a convenient virtual date, my lord.
Register of courts date. Council, 11th July.
My lord?
11th July.
It's convenient to me, my lord.
Okay.
It's convenient, my lord.
Okay, thank you, Council.
Yeah, well, thank you, my lord. And after that, my lord,
yes, I
have an application to make, my lord.
In respect of?
There is one case of Adamu Audu coming up for physical hearing, my lord, before this honorable court, my lord. It is a case handled by my lord.
Is it
the case of
court list for today?
It's on the court list, my lord. It's the second to the last, my lord.
Yes.
Yes, my lord. I learned that is handled by my colleague with whom we are from the same chambers, who is currently unwell, my lord. I saw it on the court list and I reminded him, and he is in the hospital now. He's not feeling fine. And I tried to reach the defendant, my lord, and I couldn't. So I don't know, my lord, if I can be granted a stand down, because I learned that it is coming up immediately after this case, maybe to come and address the court physically, since it is slated for physical hearing, my lord.
The matter is for continuation of hearing?
Yes, my lord.
And the prosecuting counsel is ill
yes,
as
my
well.
lord. He is not present as well. I don't know if there is need, my lord, I can come and address the court physically, but if I can do it here, that would be better for me, my lord, since the case is not going.
Unfortunately, none of the cases for virtual hearing.
Yes. The case is for physical, my lord.
Oh, it's for physical.
Yes, my lord. That is why I said.
But still, the prosecuting counsel is absent. He has like how many cases for today?
Yes.
About 5 or 6. But the challenge is he's not here.
Okay, my lord.
Anyway.
Can I come and address the court physically, or I can address the court via this mode, my lord?
One case at a time. Presently, we are on Federal Republic of Nigeria and versus Ali Kodo.
As a court, please, my lord.
So I've not read out the ruling. So it's like you have jumped the gun.
As a cop, please. I'm sorry, my lord. Much guidance.
This Adikolo, is he on bail or?
He's on bail, my lord.
The defendant who is before the court and his counsel present while the prosecuting counsel is absent. So all matters for today to be prosecuted by the NDLEA has to be adjourned to another day because the prosecuting counsel is not before the court. Prosecuting counsel who is always before the court is absent today. Registry of court, all the cases can they adjourn to the 11th or the diary is filled? 12 cases on that day. And then the ones we are to adjourn, how many? 5. So adjourn all the cases to the 11th July. Counsel, are you all online?
Yes, my lord. As the cop pleases.
Yes, all cases to be prosecuted by the NDLEA for today are adjourned to the 11th day of July 2024.
As the cop pleases. We are most grateful, my lord.
You're welcome.
Thank you.
Thank you.
Thank you to all the counsel that appeared today, and thank you to the staff of the Federal High Court as well as Fortune Technologies.
As the cop pleases.
God please. Nicola now, why should I tie shut down?
Kenan a yanzu an cire kowa ba.
Zan dai.
An cire kowa?
An cire kowa.
Ya ji ki ake kowa cikin yajin duka su da yake yi. Allah an yi ajirin ma. Allah an yi ajirin duka wata sai an ji ma. Kafan mata Muhammad. Kafan mata Muhammad da ita da mani. Hajiya ina. Bisa ga eh. Ni bana ma jin ta. Bana jin ki, ba ma jin ki mu. Ba ma jin ki. Mu ba ma jin ki.
Na ce ‘yan daɗi bidiyo bye bye a tafi.
Okay. Ba ma
‘Yan daɗi zoom. A tafi a tafi.
To sai an jima ya maki mutane namu.
A gaida Titile.
Ba a gaida Sani ba. Ya dai mu din ya ki fita ne ba.
Na kuma ki fita ne wai ma ya. Ko aminci da mayan manya.
Kin sha. Kin sha gaskiya kin sha.